Welcome back, legal enthusiasts. Today, we're diving into the high-stakes world of criminal defense, where competency and plea bargains take center stage. We have Logan Denny, accused of a serious crime, standing trial. But wait, there's a twist right from the start: an unexpected change in legal representation, a competency evaluation, and a surprising plea that's about to unfold before your very eyes. Will Denny walk away with a lighter sentence, or will the court deliver a shocking verdict? Stay with us as we break down the intense moments, the legal strategy, and the drama in this real-life courtroom.
Court is calling 2025 CR 002461 State versus Logan Denny. Can I have parties announced?
Stephanie Pitlock for the state of Texas, Your Honor.
Kimberly Bush for the defendant.
And are you Mr. Denny?
Yes, ma'am.
Okay, let's pause here for a moment. Right off the bat, we've got something important going on. The defense attorney has just informed the court that Denny's competency evaluation has been completed, and according to the findings, Denny is competent to stand trial. Now, a competency evaluation isn't just a formality, it's crucial. It ensures the defendant understands the charges and can effectively participate in their defense. But here's the catch. Denny and his defense team are waiving the right to have a jury decide his competency, which could have been a big moment for the case. So, why waive it? Is it confidence in the report, or could it be a strategic move? What do you think? Would you have waived the jury right, or fought for that extra layer of scrutiny?
One preliminary matter I'd like to raise before the plea, if I may, Your Honor.
Sure, you may proceed.
Okay. I have been retained after this case began by Mr. Denny and his family. The prior counsel had, or somehow it had been ordered that there was a competency evaluation which was to be done. That took some time to get done, but it has been done. The report found him to be competent. I fully concur with that in my professional opinion as a lawyer and my personal opinion as a person. I have the report to tender to the court if the court would like to see it. I have discussed this matter with the magistrate court, and they suggested I bring the report to you and
Yes.
that we waive the competency and proceed. Or that you declare him
Yes.
competent, whatever the proper procedure would be.
All right. So with regards to the matter of competency, State, have you had a chance to review the document from Dr. Eric Cardwell?
The state has not personally, but in discussions with defense, we've been made aware of the results, and we believe that there are people within the district attorney's office who are aware, and we are allowed to proceed.
All right.
I did discuss it with Sally Unkefer yesterday.
All right. And so both parties agree that Mr. Denny is competent to stand trial?
Yes, Your Honor.
Yes, Your Honor.
All right, Mr. Denny, you're aware that you do have a right to have a jury. If you request a jury, make a decision on whether or not you are competent or incompetent.
Yes, ma'am.
All right. Are you waiving the right to a jury to determine whether or not you're competent or incompetent?
Yes.
All right. After reviewing the report that's been tendered to the court as, if you could mark that as an exhibit, please, as
I'll mark
defense
it as
exhibit
Defense
number one,
exhibit number
and
one.
there's no objection to defense exhibit number one?
None from the state, Your Honor.
I'd request it be admitted.
All right. Defense exhibit number one is admitted into evidence. If you'll just give it to the court reporter. All right. Any arguments from either side with regards to competency before the court makes its ruling on competency?
None from the state, Your Honor.
None from defense, Your Honor.
All right. Based upon the evidence that's been submitted to the court in defense exhibit number one, and also based upon evidence that has been submitted other than defense exhibit number one, the court will find that the defendant is competent.
Thank you, Your Honor.
Counsel, you're welcome. Counsel, have you received all discovery in this case and did you review it with your client?
I have received the discovery and I've reviewed it with my client. Yes.
Court will find that the state is in compliance with discovery. Mr. Logan, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, we are.
And here we go. Denny is officially pleading no contest to the charge of theft. For those who don't know, a no contest plea essentially means Denny isn't admitting guilt but is agreeing to the punishment without a trial. This is an interesting choice, especially considering he's facing serious consequences. Now, the punishment could range from 180 days up to 2 years in state jail. But here's the twist. The plea includes a specific stipulation: no contact with Best Buy and others involved. That's a big deal. What's your take on a plea like this? Does it show a willingness to take responsibility, or is it a tactical play to avoid a harsher sentence?
Mr. Denny, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor, I did.
Did you understand you're charged with the offense of theft for property, $2,500 to $30,000? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this cause?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Logan, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 300 days in the Bexar County Jail under 1244. There's to be no contact with Best Buy. Did you understand that to do the plea?
Yes, Your Honor.
Defense?
That is our understanding.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There have not, Your Honor.
Into the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
State offers State's Exhibit 1 and all attachments are.
No objections.
All right, state, you may be excused.
Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
My client has been in jail since January 9th for this offense. It has given him the opportunity to reflect, perhaps involuntarily at first, but later on, at least partially voluntarily. I believe that he is more than ready to move his life forward. It's also my understanding that given the number of days, this is, I believe, to be a judgment satisfied. And I would just ask the court to accept the plea and let my client move forward with his life. He's a new father and he's looking forward to new beginnings.
Oh my gosh.
Hold up, this moment is absolutely loaded with emotional weight. Denny's attorney just revealed that he's a new father, and shockingly, he's never even met his child in person. The emotional stakes have just been raised. This is the kind of detail that hits hard in the courtroom. It's a reminder of how personal the consequences can be, but the judge isn't holding back. They're telling Denny flat out, Tiff, you're going to be a father. You've got to step up. And here's the kicker. They're laying down the law. about being a good influence on your child. The judge doesn't mince words, either step up or walk away. Do you think the judge is being too harsh here, or is this the tough love Denny needs?
Yeah,
Your new father?
Yes, Your Honor.
and he has not met his child yet except on video, in the video visit.
All right, so these things happen when we commit
Yes, they
crimes.
do.
So you're gonna have to change your life because you have a new child. You understand? So here's what I'm gonna tell you, and this is what I would always tell people when I was do CPS cases, when I would represent parents. If you have no intention of being in your child's life and being a good influence, just walk away. They're better off without you. You understand? So don't bring marijuana in their household. If you have issues with competency and you're on medication, you need to stay on those medications because you're supposed to put your best foot forward for your child. You understand? All right. The court is finding you guilty. The court will sentence you to 300 days in the Bexar County Jail under 1244. There's to be no contact with Best Buy, no contact with Matthew Dillon.
Wow, this is where it all hits home. The judge just handed down the final verdict. 300 days in jail for Denny. No more, no less. And here's the kicker. This conviction for theft is now marked as a crime of moral turpitude, which means it'll be on Denny's record for life, affecting his chances at things like professional licenses and employment. Ouch. This is a serious long-term consequence, and it's a hard truth about how criminal convictions follow you forever. The judge does offer a glimmer of hope, though this doesn't mean Denny can't turn his life around, but boy, is it going to be tough. So, here's a question for you two. You think the judge's ruling was fair, or did Denny get the short end of the stick?
Yarborough or Ibarbo. Yborbo. With regards to whether you have a judgment satisfied or not, they will calculate the time. I've told them to give you credit for any time that you've been there. If you're at the jail and you think you should be getting 2 for 1 or 3 for 1, that's what the jail does. I have no control over that. What I can tell you is I've sentenced you to 300 days. So you will do no less and no more than 300 days. You understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, read and go off the record. You made your life very difficult.
Well, there you have it. Logan Denny pled no contest and was sentenced to 300 days in jail, all while dealing with the heavy emotional weight of fatherhood and a criminal record that will haunt him for years. This case illustrates the tough choices defendants face and the far-reaching consequences of their actions. Denny's story is a reminder that no matter what, the law can be both a path to redemption and a harsh judge of your future. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more coming your way, so stay tuned.
Because what you're charged with and what I found you guilty of is a crime of moral turpitude. So what that means is anything that is going to require you to have a license, this is going to pop up on your record. Now, does it make it impossible for you to follow your dreams? No. It's just going to make it very difficult. You understand?
Yes.
All right. Good luck to you. You're welcome.
Thank you, Your Honor. May we be excused?
Yes.